relied solely and exclusively on the warranties. That was its pleaded case as to the checks it undertook. And having been presented in that generalised way, then it's entirely understandable why the judge dealt with it at a generalised level. To the extent that he was required to make specific findings about sample stations, he did so, and one sees that at paragraphs 153 and 154 of the judgment. So he found specifically that Shout FM had not filled in a station update form prior to the date when it required the tick box, and similarly with Radio Dudelange. And then at paragraph 154, he dealt with the bespoke agreements in relation to some of the sample stations, which we looked at yesterday. So we say the judge was perfectly entitled to deal with it in the way he did, and indeed it's difficult to see how he could have dealt with it otherwise, given the way the case was being put. Now, as I said, the judge treated it in effect as a presumption concerned with whether it would be reasonable to carry out checks. And before looking at what checks were carried out, just to make some preliminary points, the first point is that given that we are here concerned with UK copyright, then obviously the relevant question is concerned with the consent of UK rights holders. That must be what the inquiry is directed to. And if one sets this in context, we're dealing, for the purpose of this inquiry, exclusively with foreign stations. And it is Tunein's own case that, but for Tunein's intervention, most, if not all of those stations would not be targeting the UK and would have no need of a UK license. So, my lord, my lady, in those circumstances, someone, a station, an operator of a service such as Tunein, asking itself, what is the likelihood that a foreign station not targeting the UK would have a license to communicate to the public in the UK? An operator asking itself that question could only answer it to itself, there isn't a snowball chance in hell. Why on earth would a foreign station have such a license? So any responsible operator such as Tunein would, in reality, know that foreign stations would not have a license for the UK. And that ought to form the backdrop of any inquiry which it was going to undertake. What checks did it undertake? The answer, the short answer, is none. No checks at all. All it relies upon is its claim to have taken warranties. Now, as the judge found, a substantial number of the stations didn't in fact provide warranties at all because they never signed up to any terms. And just to look at the evidence on that, one of Lady Justice Rose's questions yesterday was in relation to the number of stations which were already on the site at the time when Ms. Robinson started. Her evidence was that when she started in 2011, it was between 80 and 90,000. So not as many as it got up to. I think that it seems that the maximum number it got up to at any one time might have been 120,000. Now, if one looks at the evidence as to the extent to which any stations or stations had signed up to the terms, one can see, at least by reference to a sample, in the supplementary bundle at tab 9, which is at start to page 73, the relevant question. This is a request for further information. And I think the relevant requests can be picked up at number 6 on page 76. These questions were posed in relation to the defendant's claims that stations had signed up to the broadcaster terms. And request 6 is please identify the stations indexed before 2014 whose operator had not previously accepted the terms. And then under 7, following page, the request is made in relation to the stations whose operators have since accepted and agreed to the broadcaster terms. Now, this question was then answered by Tunein, not by reference, perhaps understandably, to the 120,000 stations, but what they did was answer them by reference to a sample of 790-odd stations, which appears at tab 10, starting on page 101. Just so the court knows where this sample came from, it's a point I'll come back to, but when Wigan, for my clients, first wrote to Tunein to assert their claim, they identified, in a more or less random basis, 790 stations which they identified not being licensed in the UK that were on the platform. So these were all foreign stations. And so Tunein used this sample then to identify those which they said had accepted the terms and those which they hadn't. And if one looks down page 101 and turns the pages on it down to page 114, the court will see under the column agreed to terms various answers given. There are 3 answers, probably yes and no. It emerged on inquiry that probably means, in effect, that that Tunein doesn't have any record of anyone having agreed to the terms, but they think, for reasons which are never really explained, that they might have. But what one can see is that there is a significant proportion of these stations which, even on Tunein's own case, they could not say that they had accepted the broadcaster terms. So there was clear evidence, even on the basis of limited sample, that substantial numbers had never agreed to the terms and never provided warranties. Now, that being so, the dispute about Miss Robinson's evidence, which my learned friend referred to yesterday, slightly falls away because the fundamental point, namely that Tunein makes available stations regardless of whether they have given the warranties or not, remains. Nonetheless, just to address the point about Miss Robinson's evidence, the reason why the judge was unable to accept it was because in the pleaded case, and one sees this at paragraph 24C in the core bundle, page 233, the pleaded case was that the requirement to tick the box in relation to the update station form only arose from September 2016. In Miss Robinson's evidence, in her witness statements, she did not assert any earlier date for the station update form. And just so that one can see that, she deals with that at page 152 in the supplementary bundle. Where she refers to the update station form, paragraph 29, but doesn't give any date as to when it was introduced or when tick boxes were required. Now, it's fair to say at paragraph 30, she goes on to deal with a station called Drekstad FM. And I think in re-examination it was suggested to her that this was an indicator of the idea that the update station form might have required the relevant tick box from an earlier date. But if one reads paragraph 30, we can see that actually what she's relying upon in relation to Drekstad is what she there described as an add station form, which one infers is the new station form rather than the station update form. So she's talking about a different form there. So for the first time in her cross-examination, she suggested that the update station form required the tick box from an earlier date, and not surprisingly, given the pleaded case, the judge felt unable to accept that. The judge, contrary to what my learned friend suggests, did not misunderstand the position in relation to the different forms, and one can see that at paragraph 150, well, if one looks at paragraphs 150 onwards, in particular at paragraph 151, when he deals with Miss Robinson's evidence, he is specific in referring to the station update form. He's not confusing the new station form and the station update form at all. He's quite specific in referring to the update form in the relevant passage. And similarly, in paragraph 153, when he deals with the sample stations, he refers to specifically the station update form. But stepping back from the thickets of this, the important point, as the judge found, is that given that Tunein makes stations available whether or not they've entered into a warranty, it makes no sense for it then to claim that these warranties are fundamental to the checks it carries out and to its satisfying itself as to the rights position. It simply doesn't care about the warranties. And one sees that at paragraph 156. From Tunein's point of view, they are not important. If one then considers the warranties in detail, and I use warranties in inverted commas, I took the court yesterday to what I've called the bespoke licenses with some of the sample stations, Country 104, Mix Megapol, Deutschlandfunk, etc. And we saw there that the relevant provision is not a warranty at all. It's just an imposition of an obligation upon the station to obtain the necessary rights. As for the relevant warranties in the tick box standard terms and conditions, first of all, it's possible for the station to tick the box without reading those terms and conditions. They appear in various iterations. If one looks at the supplemental bundle, at the early stage, one sees a version of them at tab 38 in the supplementary bundle, page 383, I think it is, slightly overwritten in my copy. And it's a document headed legalese. Perhaps it doesn't act as an encouragement to anyone to take it terribly seriously. And the relevant provision appears on page 384 under Publisher Representations. Now, I won't read it all out, but what the court will see is it's essentially directed at the US rights position and is specifically concerned with, for example, sound exchange. then the later version, and this was the version which Tunein relied on in its defence. This was, as it were, the pleaded version. One sees that behind tab 4 at page 22 in the same bundle. At clause 3, and again I won't read it out, but the court will see it in general terms. What it doesn't do is make clear, obviously, the need for any licensing outside the relevant territory for the station concerned. And as the judge found, that's at paragraph 155, and there's no appeal against this finding, that would be understood by the station operator as meaning operating lawfully in its home state. I say that's not appeal. What is referred to in paragraph 28 of the grounds of appeal is a criticism that the judge was wrong to find that it was insufficient to give a warranty as to its licence status in the home state. But my lords and my lady, we say that is entirely wrong. If Tunein chooses to target the UK, it has to have regard to UK rights. That is fundamental. And that is a fundamental criticism that the judge made of Tunein. It doesn't have regard to UK rights at all. My lords and my lady, it may also be instructive just to look at what attempts were made to verify the licensing position of sample stations after they had been selected, because it's revealing as to the general seriousness with which Tunein takes this. So, if your lordship and your ladyship take the supplementary bundle at tab 46, page 427, one sees here a chain of emails between representatives of Tunein and the various sample stations asking for confirmation of their licensed status. That's at page 427 over to 430. Only one answer to those emails was received. If the court goes to tab 48, page 433, and it's an answer from country 104. And as you will see at the top of that page 433, what the station does is really comment on the position solely by reference to, sorry, at the bottom of the page is the answer from the station, where the station asks for more clarity, and then it's in Mr. Jacobs' and Tunein's answer. He refers, he's confident that country 104 is licensed in Canada. But what isn't addressed in that correspondence is any ability for country 104, any licensed country 104, to be targeted at the UK. As to the other stations, if one turns to tab 56 at page 497, in the same bundle, one sees some correspondence from an earlier time between Miles Palmer, who was delegated by Tunein to make these inquiries, and Radio Dudelange in this case. And one sees at the bottom of page 497 the radio station writing to Mr. Palmer, referring to invoice SASEM Luxembourg, as discussed. Please find the invoice 2017 attached. And as Mr. Palmer then points out, this is the 28th of August 2018, above that, I'm told this is the equivalent of a PRS license in relation to compositions rather than PPL. Is there any other form of license required in Luxembourg that you had? So no evidence was produced relevant to the phonogram license. All that was produced was a compositional license. And then there's another email at paragraph 4, page 496 in the chain, which doesn't take the matter any further. So no evidence was obtained from that station. What makes the position all the stranger is that one then turns forward to the further inquiry made a few days later by Mr. Palmer of RTL Letzeburg at page 499. And here, Mr. Palmer, having a few days earlier pointed out that a SASON license wasn't going to cut the mustard, asks the relevant station to provide a copy of their SASON agreement. And one sees that in the email at the bottom of page 499. He seems completely to overlook the fact that what he should be interested in is finding a license which would entitle the station to target phonograms at the UK. As for one of the other stations, Urban 96.5, it claimed, in response to these inquiries, that it didn't need a license because it purchased the CDs it played. And that, one sees Mr. Straley's evidence in relation to that. We won't bother to go to it now. In the additional supplementary bundle in cross-examination at page 2, sorry, tab 2, page 25. So the idea, which is suggested in Malone Friend's skeleton, that having made the checks of the sample stations, it got satisfactory replies, makes no sense. More generally, the suggestion that Tunein is a good citizen like that, which one sees repeatedly set out in Malone Friend's skeleton, was evidently not the view of the judge, as one sees from paragraph 200, little Roman 2 of the judgment, where he finds that he does not accept Tunein's contentions that it goes out of its way to work with copyright owners, etc. There's no appeal against that finding. And indeed, there was copious evidence as to the unsatisfactory nature of rights holders' attempts to get Tunein to deal with the issues raised by their service. It's dealt with in Mr. Sternberg's statement, which one finds in the supplementary bundle, tab 19, page 259, where in that passage he's dealing specifically with the notice and takedown provisions and the 3 strikes policy. The 3 strikes policy upon which Tunein relies states that if a user has uploaded content and the service has received more than 2 takedown notices compliant with the DCMA, I'm reading from the top of page 261, Tunein has a discretion to terminate the account. But as Mr. Sternberg explained, that had happened in cases, and there have been no, in relation to stations in the US, and there have been no implementation. Another feature that Mr. Sternberg referred to, and indeed Tunein relied upon, was an arrangement Tunein had reached with Sound Exchange, whereby Sound Exchange would notify Tunein of non-compliant stations, and then there would be some letters written and a procedure implemented for the US. Now, my lords, my lady, from my client's point of view, we're not concerned with the US, we're concerned with the UK, it was Miss Robinson's evidence that Tunein's working assumption was that if a US station was non-compliant in the US, it was not licensed anywhere. Reasonable working assumption, one would have thought. One sees that at paragraph 42 of her first statement, tab 13, page 156 of the supplementary bundle. Now, on that basis, therefore, if Tunein was told by Sound Exchange that there was a non-compliant station, and if Tunein had the slightest concern for rights holders outside of the US, what it should immediately have done is for, regardless of its arrangement with Sound Exchange, block that station outside of the US. They didn't do so. Similarly, Mr. Sternberg gave evidence as to notices served by Sony specifically, and one sees this at paragraph 35 of his first statement. That's tab 16, page 243. And the way in which Tunein dealt with those was simply to geo-block for the US, but to leave the stations available elsewhere, despite the fact that on the basis of its working assumption, if these stations weren't licensed for the US, they shouldn't have been licensed anywhere. Sorry, they shouldn't have been made available anywhere. And moreover, as Mr. Sternberg recounts, these stations that were notified by Sony were often restored despite repeated notifications. My lords, my lady, a further point. How, one might ask, can we be expected, my clients be expected to enforce their rights if Tunein won't even reveal what stations it lists? It won't provide a list, as one sees from the supplementary bundle, tab 29 at page 33, where Sound Exchange asked for such a list. Perhaps it's worth just quickly turning out in the course of discussions.
I beg your pardon, I'll give you the reference again.
It's tab 29, page 333. I'm sorry, I think I said 33. And it comes in the chain of correspondence between Gary Greenstein, who is Tunein's US attorney, and Sound Exchange. And what Rianne Elpert asks halfway down page 333 on the 23rd of September 2016, they want a list of services on the directory if possible, etc. And Mr. Greenstein's response at the top of the page, as I've spoken with Tunein, they don't share the requested information with any third parties. That is simply not something they're prepared to do. Moreover, one can see their attitude from what happened in this case. I've already referred the court to the list of 790 stations. That list was provided on the 7th of 2017 under cover of a letter from Wigan, and one sees that in the supplementary bundle, tab 60. The letter starts at page 516, and the list starts at page 520. And the list is accompanied by the station names with URLs. Now, what was the response of Tunein to that? Did they geo-block those stations as they claimed to do within 48 hours of receiving notice? No, they did not. They refused to take any action until 4 months later when my client threatened to commence proceedings, and only then did they take action, and not wholly effective action, to block the stations. But my lords, my ladies, it is significant that this list included a number of stations operated by the operators of what are called the premium stations. Just to go down a little byway, I hope this won't take too long, but your lordships will know, and your ladyship will know, that there are premium stations which were a load of specially created stations, largely provided by 4 companies with which Tunein had made special arrangements for specific Tunein content. There were about 140 of these premium stations. They also provided non-premium versions of those stations as it happened. So a lot of stations being made available. Now, if one sees the list that we're looking at, page 537, one sees at number 756 aceradio.net, and then if one turns to page 539, number 827, 828 in the list, 0.977 today's hit, 0.977 adult hits. 834 is top 40 pop hits, that's an addicted to radio channel. And then 840 is a big R channel. Now, those, so that the court knows, those were all operated by these premium providers. And so it ought to have been blindingly obvious to Tunein that the very people who it had contracted to provide these premium stations didn't have the necessary license. Did they, as a result, block access to those stations for the UK? No, they did not. Not until after these proceedings had been commenced and after the issue had been smoked out by the pleadings. So the idea, my lord, my lady, the idea that Tunein is a respecter of rights and takes the position of rights holders seriously is contrary to the evidence. So, my lords, my lady, we say that even taking the approach to the presumption that the court did, the judge was fully entitled to find that the presumption was not rebutted. A moment's thought would have told Tunein that none of these foreign stations were going to have a license to be targeted at the UK, because why would they? And to seek to hide behind warranties in the form that they were was merely a fig leaf exposed by the fact that Tunein made these stations available regardless of whether or not people gave these warranties. The reality is that Tunein knows that it makes available stations to the public in the UK in circumstances where none of the foreign stations has the necessary license. That must be the case. So we say in those circumstances, whatever the presumption means, and whatever is required to be proved in terms of knowledge, clearly Tunein has the required knowledge. I'm now going to move on to consider the PROAB, which is obviously a different topic, raising somewhat different considerations. Now, in relation to this, just a prior point, my Lady Justice Rose raised a question yesterday about the number of people who signed up to the PROAB, and the evidence on that, we only have the figure, that, at least as far as I know anyway, we only have the figure that we saw yesterday of some 150,000. We don't know what the position was prior to disabling of the record function. Lest it be relevant, there was some dispute on the evidence at trial as to the extent to which people were interested in the record function. And the court will find in supplementary bundle tab 18, page 257 to 258, some evidence from Mr. Grant as to the complaints that arose from withdrawal of the record function. Beyond that, one can't really take the matter. the extent of usage may have an impact on any inquiry, and that may have to be explored there. At this stage, at least, the court just has to approach it on the basis that this function was provided and it was a useful function. Now, there are two aspects to it for the purpose of the claim. The first is the impact on the communication to the public by Tunein, and then there are the copies made by users as a result. Two distinct infringing acts. So far as the first is concerned, the way that the judge viewed this, and the way we invite the court to view this, is that this has to be seen as part of the overall package that is provided. One can't just hide it off as some distinct recording function that is separate from the service, because that's just not the way it is, or it was when it operated. It's an additional feature whereby Tunein commits the act of communication and making available. And the effect of it is to give access to users to my client's works on a permanent basis. Thus, the content ceases to be merely streamed, and TI permits users thereby to make copies of it available effectively, as the judge found, as permanent downloads.
Mr. Cullen, you say part of the same act of communication. Can I just ask a question about that? I'm sorry, we're getting feedback. Let's imagine the user who is using the Pro app, and he's got to the point where the pre-roll is played and the station that he's interested in is streaming and playing on his plan. Now, let us assume, for the purposes of argument, that there's no communication to the public by Tunein at that point.
I just wanted, we've lost the master for us. I need to be back, I'm sorry.
So we assume that at that point, there's no communication to the public by Tunein. Obviously, I appreciate your cases to the contrary, but I want to test it on the assumption that at that point, there's no communication to the public. The user then enables the record function. Do you say that on the assumption that I've stated, that converts something that was not a communication to the public into something that was?
My lord, yes, we do. Because the intervention to give access to the work has its own distinct feature. And that is to say that the user is then able to make a permanent copy of it.
Sorry, can I just be clear? Are you talking about if he actually starts recording the song? Because I thought the point was that it was just the having the ability to record the song and record the pre-roll advert, if you're so minded, is what converted it, if it wasn't already a communication to the public, into a communication to the public. I thought that was what the judge found, but are you saying that it's that if the person actually records the song, by recording it, he not only makes a copy, but converts it into a communication to the public if it wasn't already?
No, my lady, I'm sorry if I didn't mean to put it that way. And it's slightly difficult because one is having in this thought experiment to divide up the two because of the way Lord Justice Arnold poses the point. But if one takes Tunein out of the first bit of the communication, if you like, when one is considering the making of the recording, one can't subdivide that from the fact that there is a stream being provided, and so it is part and parcel of the act of communication. That is to say, the act of communication that Tunein commits is that it both provides the stream and the recording functionality. So it thereby gives access to the user by providing the content and the it's an important feature that, and it's a distinction from the Amstrad type case, that here it's the content and the recording functionality that is being provided. It is not only...
But that didn't quite answer my question, which was that when somebody signs up to ProApp and is listening to a radio station but not recording it, does the mere fact that he's signed up to a service which now would enable him to record it if he wanted to, but he's not actually recording it, does that itself convert something that was not previously a communication to the public into one?
My lady, yes, I'm sorry if I didn't answer the question. Yeah, yes, my lady, because it is thereby, bearing in mind that we know that actual access isn't necessary. It's providing a service whereby someone may access, and so providing the potentiality, we say, is sufficient. It's obviously a fortiori where the actual recording is made. Now, I've referred thus far to it simply as recording functionality. It's perhaps important to recognise that it's something slightly more than that, in the sense that, and this is a distinction again from the sorts of services which my learned friend refers to, a sort of straightforward recording, the ability to record on one's phone or something, that in providing the streams and enabling the user to record the streams, Tunein also enables the user to bring the metadata with it. And what that enables the user to do, not only does it provide pleasant features like album artwork appears on the user's screen, but it also means that the user can skip between tracks. And there's a function referred to as the intelligent skip function, so that a user can say, for example, record an hour of a broadcast radio stream, and the app will effectively divide that into the different tracks, so that the user can then skip between the tracks, can get on his or her device information as to what the tracks are, and the song title, the artist's name, etc. That, apart from anything else, serves to emphasise that this whole part of the service is music focused, because otherwise why would Tunein enable that aspect of it? Now, it's, as I think was revealed by the discussion between Lord Justice Arnold and Mr. Howe on, I think it was yesterday, in relation to this, it's perhaps most instructive to consider this issue in relation to Category 1 stations, because they are, in a sense, at the sharp edge of it, because they're stations which are otherwise licensed. Now, it's a feature of the Category 1 station licenses, as one would expect, that they prohibit copying. And one can see that from the standard PPL license, which is in the supplementary bundle, tab 8, page 58. I'm going to start at page 51. And there are various versions of this type of license, but they're of a piece for relevant purposes, I think. And so this is the form of license which a UK radio station will enter into, this is for a traditional radio station, but it will cover simulcasting, and there's a separate but similar form of license for a webcaster. And so far as relevant for present purposes, the license conditions include at clause 4.1 on page 58, the licensee shall not make or permit to be made any recording of the repertoire containing programs commit any of those acts expressly committed which deliberately encourages or induces home recording or re-recording of any of the services subject to the terms. Now, that is important because it indicates that what is happening is beyond the scope of the license. And that is relevant for this reason in particular. The judge dealt with this on the basis of new technical means, and we would commend the judge's approach to the court and invite the court to accept that. But the judge could equally, and this was the way it was put at trial, and this is one of the things that's raised in our respondent's notice, along with some of the other points I mentioned earlier. The judge could also have dealt with it on the alternative basis that by this means a new public is being targeted. And, my lords, my lady, this in a sense has echoes of the sort of approach one sees in Raphael, that one considers what audience was targeted by the PPL license. Answer, we say, an audience receiving a linear, real-time, non-interactive stream, not an audience that is able to make recordings and thereby use the intelligent skip function and all the rest of it. So we say taking, here it requires a slightly more nuanced analysis. You haven't got the simple territorial distinction, but we say nonetheless, it's legitimate to view this as a new public because it is a different form of consumption. People are consuming it in a way which not only not taken into account by the PPL license, is expressly prohibited by the PPL license. My lord, my lady, I was going to move on. I'm making quite good progress. I don't know if this is a convenient moment to break for a couple of minutes.
Yes, Mr. Cullen will break for 5 minutes until 11:47. We're just waiting for Lady Justice Rose, I think. She's just arrived. Mr.
I was going to move on to consider accessory liability, which is obviously an important area of the case, given the way my learned friend puts it. But I think I can deal with it, I hope, fairly shortly. The first question is what wrongful acts, or whether wrongful acts are being committed, which Tunein could be accessory to. The first and more important aspect is in relation to the wrongful acts of operators. And the judge found, and we say correctly, that the station operators commit wrongful acts, and one sees that at paragraphs 192 to 195. Now, the only ground of appeal in this respect is the argument that they're not targeted at the UK. To some extent, I addressed that yesterday in relation to the targeting of the Tunein site. And we say the judge's approach to this question was right for the reasons he gave, namely for stations which are knowingly and willingly on the Tunein site, the position is quite clear. But we say that even for the other stations, it's an objective test, and that objective test is met for the reasons we looked at yesterday. And as the judge noted at paragraph 194, for all relevant purposes in this context, it's an objective test with it's a tort of strict liability. One might note, parenthetically, that the alternative, namely that one has to conduct some sort of subjective inquiry in relation to each and every station as to the extent to which it was aware of what was going on and consented to it, we submit cannot be a sensible approach to this question. And the judge was correct to treat it as he did. Then the second question in relation to acts of infringement by users, which relate solely to the recordings on the Pro app. So far as that is concerned, the judge found they will have been making unlawful copies in certain circumstances, and there is no appeal against that finding. So that brings one then to authorization. The leading authority in modern times on this has become Newsbin and Mr. Justice Kitchen's list of relevant criteria. I'm not going to take the court to that unless it would be of assistance. Mr. Howe accepts that with one caveat, and that is to say that Mr. Justice Kitchen considered one of the relevant factors the inevitability of infringement resulting from the relevant involvement, and Mr. Howe balked at that, I think on the basis of what Lord Templeman said in CBS and Amstrad, in particular at page 1055, where he referred to a passage from Laddie, Prescott and Vittoria, which talked about the use of materials being almost inevitably being used for the purpose of infringement. And Lord Templeman states the thought that the proposition was stated too widely. That's at the top of page 155, that's page 582 and 82 in the bundle. I don't think we need to look at it, because what Mr. Justice Kitchen was doing was simply identifying potentially relevant factors. He wasn't setting out, didn't purport to be setting out a fixed list of boxes which have to be ticked or requirements which have to be fulfilled, and he wasn't suggesting that inevitability of infringement will inevitably lead to one answer. It was merely part of the relevant range of factors, and we submit it's entirely sensible to view it as such and to take it into account as such. Now, that then brings one to consideration as to how that plays into the chain, if you like, in this case, because this is a case where the authorization is by someone, as it were, downstream from the original wrongful actor on this analysis. So one has the stations transmitting the content, and Tunein is coming in, as it were, downstream from that. Now, there are a host of cases in the web blocking context where that sort of downstream authorization has been found. So, for example, in Dramatico, one has at tab 32, page 590, paragraph 91, a finding of authorization in a BitTorrent context of the uploader's act of communication. And so in that context, the uploaders are, we say, in the analogous position to the radio stations.
I beg your pardon, Mr. Cullen, I was reaching for the authorities bundle. Can you give me the reference again?
My lord, it's page 590 is the start of the report. The relevant passage is paragraph 91. Sorry, it's a paragraph 81 is where the conclusion is reached. So what your lordship did in this case was address infringement by operators under the heading authorization at paragraph 73, considered the various features, and then the conclusion is reached. The operators at paragraph 81, the operators of TVP do authorize its users infringes act of copying and communication to the public. And the court has earlier found that the users commit the act of communication when they act as uploaders into the swarm, as it's called in that context. So they are, if you like, as I'm characterizing it, upstream from the process as regards Pirate Bay, but Pirate Bay nonetheless authorizes their communication. Similarly, one has the same position in BitTorrent cases, 1967 limited to paragraph.
Well, can I just ask you to pause there for a moment? As you can see from paragraph 81, one of the questions in that case was whether it could be said that the Pirate Bay was granting or purporting to grant users the rights to do the acts complained of. And the argument against that was that Pirate Bay's stance was one of open defiance of the laws of copyright. They deliberately took the view that you shouldn't have copyright in this situation. Copyright should not be an impediment to free consumption of music on the internet. And they quite explicitly thumb their noses at any attempts at enforcement. Now, therefore, in one sense, you could say they were most certainly not purporting to grant the right to do it, because they weren't saying, we give you the right lawfully to do this. Rather, their stance was one of, we grant you the right to do this, ignoring the law. And I took the view that was enough. But are you saying that Tunein falls into that category?
My lord, yes, I'll come on to develop by reference to particular facts here, but my lord, we do say in effect that yes, what they are saying to radio stations is, come onto our service and we will thereby allow you to be targeted to our global audience, and in particular, present purposes, to the UK audience. They are thereby authorising them to target that audience. Now, my lord, one can get into emotive language about piracy and the like, and the Pirate Bay operators had their own.
Well, ignoring the emotive term piracy, which I agree with you is best avoided in this context, in this case. I mean, it's different with Pirate Bay because they proclaim themselves as pirates. But coming to the present case, I agree it's best avoided. Well, it comes, as I understand it, this ties in with your earlier submission this morning, that Tunein is not a respecter of UK copyrights. On the contrary, it is very far from a respecter of UK copyrights, you say.
My lord, yes. Well, not really, I say the judge found as well. My lord, yes.
Okay, thank you.
But in a sense, that these are factors. One could imagine a case of authorization where those weren't those features weren't available, weren't present, but nonetheless, there may be the act of communication.
I mean, you say, Mr. Cullen, that the judge found that at 200 sub 2, where he specifically did not accept that they went out of their way to work with copyright owners and licensing bodies to avoid infringement by station operators and acted promptly to remove operators reported. He said, I don't accept it, and there's no appeal, as I understand it.
My lord, yes, precisely. Just to deal with what I'm characterising as this downstream point, if one looks also at Paramount, this tab 44, page 1004, is where the report starts. And this is, in a sense, a closer, functionally closer service to the one we're concerned with, because it's more like conventional linking.
So I must have got the page wrong, Mr. Cullen. Which page was it?
The report starts at page 1004.
Thank you.
Picking it up at paragraph 37 on page 1017, having already found that the operators communicate to the public, at paragraph 37, the court finds that the users also communicate to the public by supplying links. So in a sense, they're the upstream people providing the content, if you like, as a shorthand. So they're in the functionally equivalent position to the stations in our case. And having made that finding, the court then says in paragraph 38, the claimants contend the operators of the website authorise the communication by the users, and the court accepts that. So again, it's as it were, a downstream authorisation of an act, someone who is supplying the ultimate content. Now, in this case, it's not at all like the Amstrad type situation where you provide a recording device and it may or may not be used for infringing purposes. The relevant act in this case of the relevant part of the infringing act which Tunein service provides is effectively the targeting of the UK. That is an act which can only take place by virtue of Tunein service. It is inseparable from the wrongful act with which the court is concerned. And Tunein, if one wants to talk in terms of authorization in the strict sense, Tunein's authority is required to allow the stations onto the site to enable this activity to take place. Tunein could bar the stations, can take them down at any stage. And my lord, my lady, we looked yesterday at the terms and conditions, but it's worth looking at those again. Perhaps at tab 4 in the core bundle, page 21. There are terms of service at clause 1, which govern the use of the service to make available the transmissions of your station to Tunein's global audience. Now, for people who sign up to those terms, that's just an authorization in clear terms. But my lords, my lady, even for stations which haven't expressly signed up to those terms, that's just a description of what's going on in this arrangement. By allowing stations onto its service, Tunein is allowing them to be targeted at the UK and thereby commit the wrongful act with which we're concerned.
But for this to work, you have to establish that the radio stations are themselves targeting their stream to the UK by being on the Tunein service.
Yes.
Right.
And sorry, but yes, my lady, and as I said earlier, we say that is clearly the case for the reasons the judge gave.
Yeah. I see. So it's a kind of, it's a circular argument in a way. It depends on Tunein communicating to the public in the UK, that also being the stations communicating to the public in the UK, and therefore Tunein is authorising them to do that.
Yes, the way the judge found was that Tunein commits its own act of communication. It has its own responsibility for the act, for the primary act. But for the purpose of this analysis, let's park that. He also found that the station operators communicate to the public in the UK. Part of the way, and a necessary part of the way they do that, indeed the only way they do that, is through the Tunein service, because that's the only way in which they become targeted at the UK.
But if they had a PPL licence, Tunein, if they took a licence from PPL, would that cover not only their communication to the public, but also the radio station's communication to the public, and also them authorising the radio station's communication to the public?
If they had a licence to communicate all of their station streams to the public in the UK, then it would cover all of the wrongful acts with which we're concerned. Obviously subject to its particular terms, but...
Well, that's what I'm asking, subject to its particular terms. I'm just wondering whether the standard PPL licence does cover that, or whether Spotify and all those, the competitors that you showed us, I mean, that their licences then entitle them to do all those things, to authorise the providers upstream, as you put it, to use their service to target the UK?
I assume so. They are all licensed for whatever they do, Now, Spotify is a slightly different case because it has its own, it hosts its own content and provides its own content.
But it also provides radio stations.
I think they call them radio stations, but I think they may well be Spotify created stations. I'm not sure.
I'm not sure all Spotify created stations. I mean, we can check, but I mean, presumably they would be they would get, if they have a license, which they obviously do, that license would cover what my lady is talking about.
Evidently, that must be right. And I mean, it's a banal way of putting it, but whatever license Tunein takes will cover whatever activities it wants it to cover. There's no question that it could be licensed, and indeed, what my clients devoutly would like that they be licensed. But if my lady's question is, can the necessary license be granted by PPL?
No, that's not my question. My question is, all this extending out of the one act that they do, which is communicate to the public, therefore has all these repercussions for creating liability on the part of other people and secondary liability on their own part. Why this piling on of these different acts? What relevance it has when people, whether this is recognised by the system that is currently in place.
My lady, there is no standard form licence for an aggregator of radio stations of the kind that Tunein is, so far as I'm aware. The standard radio licence, PPL licence that we looked at, is for radio stations broadcasting their own radio broadcasts, their content. If Tunein wants a licence, I think I'm correct in saying I'm not involved in the licensing side of my client's business. It would require a bespoke licence. There's no scheme that operates.
No, but taking an ordinary restaurant or a pub or something that illegally puts a radio on in its restaurant without paying, without having a license, is it also thereby causing the radio station to infringe its own license with PPL and commit an unlawful act?
No.
Without even knowing that they're doing it?
No, my lady, because they would be, they would, one assumes, have a license for the relevant territory. So they will not be committing a wrongful act. The reason, without getting into the detail, the reason why a restaurant playing a radio needs a license is because it's committing a different act, again, which is public performance. So there's a different restricted act engaged by that activity. My lady, some of the complexity in that, I'm sorry, some of the complexity of causes of action is really a function, in a sense, of the way the case is defended by Tunein. In that we say, to put it very crudely, as I did put it crudely, I think, in opening, one has a load of stations broadcasting content to the UK public. It's sure as hell someone is committing the restricted act in this country. My learned friend says it's not him. Well, we say if that's not right, then it must be the stations. Because one way or another, my client's works are being communicated in a targeted way to the public in the UK. We say the simple way of answering the question is to say that Tunein itself is committing the relevant act. But if that's not right, then we say it must be that the stations are, and that Tunein is authorising that activity. What there cannot be, we would submit, in a cri de coeur, is a world in which this is going on, but no one's doing anything wrong. That cannot be right. So I think that deals with the station operators, and then comes to authorization in relation to the wrongful acts of the pro-act users making their illegal copies. Really this, I make very similar submissions to the ones I've already made in relation to the way in which the provision of the pro-act provides the ability to make the copies, and does so in a way that is entirely different, we say, from the sort of Amstrad type analysis. In this case, with Amstrad, all that was provided was the recording hardware, if you like, the machine, and users could choose what they liked to do with it. In this case, importantly, Tunein doesn't just provide the machinery, it provides the content as well. It provides the whole thing, whereby the wrongful act is committed. And it provides it in such a way which we say clearly connotes an authorization being given by Tunein to its users to make these copies. You could not only make the copies, you, our users, we will provide you with the metadata, which enables you then to skip between songs. We'll provide you with the artwork, all of that. So we say again, it's a clear case of authorization. Then the next heading is joint tortfeasorship, where very similar considerations arise, although the conceptual analysis is slightly different. But we say, again, this is as clear a case as one could like of joint tortfeasorship. The key authority is obviously C. Shepherd, which is tab 34 in the authorities bundle. Malone Friend took you to this yesterday, page 667. Is the particularly pertinent passage from Lord Sumption's judgment. And he deals with the point at the top of, in paragraph 41, bottom of paragraph 41, at about letter C, where he notes that the mere supply of equipment which is known to be capable of being used to commit a tort does not suggest intent. Other circumstances may do, because here we're not dealing with mere supply. We're dealing with something much more involved, whereby not just the equipment, but also the content is supplied. And then if one passes down, Lord Sumption addresses the Grokster case, and as Lord Justice Arnold accurately predicted, we put ourselves squarely within the sort of analysis one sees in that case as set out towards the bottom of page 667. Before leaving this case, it's perhaps just also...
It might be worth noting that it's slightly compressed, but he's not referring there either to Sony or Grokster, I don't think. I think what he's referring back to is Dramatico, paragraph 38, which is exactly what he describes in 43, which is file sharing website.
My lord, that's right, I'm sure, my lord, because it's not quite an accurate description of the Grokster situation. My lord, yeah. Just before leaving this case, just to make it clear, and I'm sure the court has this, but in Lord Neuberger's decision, he expressly makes plain what I think is obvious anyway on the authorities, paragraph 60. It's unnecessary to show defendant appreciated that the act which he assisted in pursuant to the common design constituted gave rise to a tort or he intended harm. All that's necessary is that you've got to assist in or be party to a common design to commit the relevant act. And if that happens to be a tortious act, the consequences follow. It's perhaps also instructive in this context to look at one other authority on this area, which is the Football Data Code Sport Radar decision at page 712 in the authorities, where it has a somewhat complicated factual history and procedural history in this case, because as we know, it went to European court. But essentially what was going on in this case was that a company called Sport Radar was allowing bookmakers to link to infringing content to provide football data services to visitors to the bookies' websites. And questions arose as to whether, who was acting in concert with whom for the purposes of a joint liability claim. This is in the context of the database right, where no question of authorization arises. So it was just dealt with as a matter of joint tortfeasorship. And the relevant passage from Sir Robin Jacobs' decision can be picked up at paragraph 93 at page 741, where he has addressed the authorities with which we're familiar, particularly obviously Amstrad. And then he says at para 94, because it acts in concert with Sport Radar, Stan James is plainly a joint tortfeasor with Sport Radar. Now, just pausing there, that was regarded as plain. It didn't really need any discussion. We say that is effectively our case. Sport Radar being the radio station, Stan James being Tunein. What the court then went on to consider in this case is whether the Stan James, so Tunein, whether it jointly participates with users, because there the wrongful act that was relevant was extraction and reutilization of data. So the users were doing that unwittingly, or so unwittingly in the sense they didn't know they were doing anything wrong. And the question was whether Stan James was jointly participating with that. And in a pithy question and answer of paragraphs 96 and 97, Robin Jacobs decided that they do. That's to say, the question being posed, if A has a website containing infringing material which will inevitably be copied into the computer of B if he enters that website, is A a joint tortfeasor with B? And he answers yes. Now that's a slightly different situation, as I said, from our case. Our case, if one is drawing analogies, is with the relationship as between Sport Radar and Stan James. But nonetheless, we say it's instructive and illuminating guidance when one comes to consider the position here, where the involvement of Tunein inevitably, by its nature, results in, and is intended to result in, the targeting of station streams to the UK, and therefore a commission of an act restricted by the UK copyright. Now, all that leaves me to deal with, I think, is departure from the EU jurisprudence. And I'm going to keep this, I hope, fairly brief. The first point, which I think Mr. Howe accepts, is that if this is to be done at all, it can only be done prospectively. And the court has seen the restrictions, if you like, upon the court's freedom to depart in such circumstances, and the court should only do so in exceptional cases. That's not how the court put it, but that's the gist of it. And we say this is not, by any stretch of the imagination, an appropriate case for it. But we also, as I will come on to, say even if one does, it doesn't assist the defendants here. I'm going to focus on what is actually raised by the appellant's notice, which is to say departure from the case law as it applies to hyperlinking. I'm not going to fall into Mr. Howe's invitation to start trying to rebuild the whole house of authority on this from the ground up, given the time available and given the way in which the appeal was advanced, both in the appellant's notice and indeed in my own friend Skeleton, which was restricted purely to the question of hyperlinking. Now, the first point, my lords, my lady, is this. It's suggested by my learned friends that Svensson is inconsistent with recital 23 in the Information Society Directive. That is the recital which requires that there be a transmission. Now, I touched on this yesterday. 2 points. First of all, it's clear that there does not in fact need to be a transmission. It is enough content to be made available, which I think Mr. Howe is inclined to accept. And the second point is that in any event, there is here a transmission, evidently, because the stations transmit their content. The question and the issue for this court is who is responsible for that transmission.
Well, can I just be clear what you mean by that? As I understand it, what you're referring to there is the fact that in the present case, we're dealing with streams. We're not dealing with static web pages.
My lord, yes, yes. My lord, the nature of the transmission might to some extent depend upon the content. But given the nature of my client's content, it's the streamed content that we're interested in. And that is what is transmitted. And as I say, the issue is who is responsible for that transmission. I showed the court authorities yesterday as to how there may be more than one party involved in the transmission. And we say that recital 23 does not compel any sort of conclusion that linking is somehow outside of the relevant act. My lords, my lady, nor is it compelled, contrary to what my learned friends suggest, by Article 8 of WIPO and the agreed statement thereto. That is the agreed statement which refers to the exclusion of mere provision of physical facilities. And just to look at some authority in relation to that, tab 109 of the authorities bundle contains an extract from the von Lewinsky text, and it starts at page. It's in a chapter dealing with Article 8, and the particular passage, which I think we did look at earlier, but just to go there again, is at 7.8.43, which identifies the sort of things that were in contemplation.
Page, please.
I'm so sorry, 3194. Well, I hope you will have paragraph 7.8.43.
Yes, thank you.
And there is reference to the basic proposal according to which the mere provision of service-based communications connections, facilities for carriage and routing, etc., were to be excluded. And so that, as indicated by the authors, is the manufacture of cables and computers, that sort of thing. We're not in that world at all. While we are in this, it may also be instructive to look at page 3184. And this is paragraph 7.8.17. Where there's discussion of the public. And if one reads that, one can see that there's some arguable dissent from the notion that the new public is a proper limitation. But we say revealingly what the authors go on to consider is, they say at the top of the following page, any new act of making available a work via the internet, for example, through a separate upload or link on a second website to the one where the work was originally made available, or through a search engine, represents a new act of making available. The court will see from the footnote that they note the Svensson decision, apparently not very happily, in the sense that they think Svensson took too limited a view by applying the new public test. But so far as whether the relevant act of linking, whether the act of linking can be an act of communication, the view expressed there seems to be that it can be.
Can I just be clear, Mr. Cullen? So, as I understand it, you're not saying that actually there is a retransmission of the stream by Tunein. You're saying it doesn't matter whether Tunein are actually physically, that has a meaning in this context, physically transmitting the stream. By asking your question, who is responsible for the transmission, you seem to be asking a slightly different question, which is, even though it's only the radio station which is actually transmitting the stream, there can be more than one person responsible for that transmission, and Tunein is a person responsible for that, regardless of whether it's actually to be treated as retransmitting the stream itself through its service. Is that fair?
That's fair, my lady, and the benchmark by which I say that question falls to be answered is the test set out in all the authorities that we've looked at, namely, does Tunein materially intervene to give access to the works?
And specifically, you say it does with reference to the UK.
Exactly. And that is why one keeps coming back to targeting, because the nature of Tunein's intervention is what gives rise to the wrongful act in the UK. Without Tunein's intervention, there would be no wrongful act in the UK, because the underlying stations are not targeted here. That's at the core of this. Now, just briefly, the appellant's skeleton argument relies on various European Court of Human Rights decisions and foreign decisions in relation to defamation, which I'm not going to say anything about beyond the fact that they are irrelevant and unhelpful for at least two reasons. First of all, the relevant act in a defamation case is conceptually quite different from communication to the public. As the cases show, a common law in the UK at least, publication involves, in defamation involves a mental element, secondary publication involves a mental element, in a way that is quite different from anything that one sees in section 20 of the Copyright Designs and Patents Act. To the extent that my learned friends refer to those decisions as representing some broader principles arising from fundamental freedoms, of course, in defamation cases, there isn't the same competing freedoms and rights. One doesn't there confront a position that arises in this sort of case of having to bear in mind property rights of intellectual property owners. So whatever balancing exercise, whatever calculation the court is doing, is simply a quite different one in relation to any defamation case. Of course, fundamental freedoms, which we hear a lot of in my learned friend's skeleton, they refer, for example, to the right of plurality of media and arts. Of course, now we no longer have the EU Charter applicable here. And so and I think that is what those sorts of rights arise from, so far as one can ascertain. Here, one is presumably just left with the Human Rights Act, which has a slightly narrower range of fundamental freedoms and rights. But I'm not going to go down that thorny path. Then my learned friend refers to various other jurisdictions, the position there in relation to linking. And I think my learned friend accepts that the position in those other jurisdictions does not reveal any clear, consistent approach to this question. We set out in our skeleton what we say. In summary, Australia, one gets no assistance because there is a different statutory regime. In particular, communication to the public, the act of communication can only be committed by the person responsible for selecting the content, in effect, which is quite different. We say the position in Canada is there is clear authority that linking can give rise to communication to the public. As to the USA, again, there's a different statutory context. There's no communication to the public right as such. It's dealt with largely on the authorities as the display right. And that's given rise to something called the server test in Perfect 10. And as we set out in our skeleton, that has received mixed reception in various places. I think, perhaps, what I would do is commend to the court the article by Jane Ginsburg and Luc Bugiardo, which the court will find, and I'm not going to take court to it now, but it's tab 101, page 3027, and in particular 3052 to 3067. And what the authors there do is consider the server rule in the context of a wider discussion about linking generally, including the discussion of the European position. And they, in summary, conclude that the server rule focuses too much on technical aspects and fails to reflect the user experience, and points out that links have very different functions in different contexts. And they they develop the analogy of the library card, which one sees, and which my learned friend, I think, referred to, and describe what some links do as operating in such a way as not being like a simple library card, but rather they bring the book to you open at the correct page. My lord, we say that is very much what Tunein's links do, quite apart from all the other bells and whistles that go with it. Now, my lady, I'm not going to go into that in any more detail, but just to come back to this case. We say there's no reason to depart from EU law because it adopts an appropriate test and it's applied by the judge in an appropriate way. Even if the court was going to depart from EU law, then where does one go? My learned friend says, well, it's just two questions. Is there an act of communication? Is it to a public? we say putting it in that way really just digs Tunein into a deeper hole. Because the first question, is there a communication? Well, yes, clearly. And for all the reasons I've given, it is clearly Tunein's communication. Because without Tunein's intervention, there would be no communication to the public in the UK. So to that extent, if it's too simple, two-question problem, the first question admits of an easy answer. The second question is even simpler. Is it to the public? Well, obviously, it's to the public. And now, in that way, one jettisons all this difficulty about new public and who's taken into account by any prior communication, and one simply sees it in the way rather as in the von Lewinsky book, being a simple matter. You commit the act of communication by providing the link, and you're doing so to the public, therefore you are liable. So, my lords and my lady, putting it in this way does not assist Tunein, it just gives rise to a simpler and quicker way of arriving at the same destination that the judge reached. Finally, my learned friend says, well, even if one doesn't rebuild the whole edifice, he says that the court should not follow GS Media because of its introduction of the requirement of guilty knowledge. And it's fair to say, as everyone I'm sure appreciates, that is something of a novelty and in some minds a heresy in the field of copyright infringement, which has generally been a sort of strict liability. Well, my lords, my lady, fine. Get rid of the GS Media presumption. What you're left with is a position where TI is liable, Tunein is liable anyway, because it communicates to the public and it communicates to a new public, for if that's relevant anymore, according to my learned friend, for all the reasons I've given. What the court in GS Media did was attempt to mitigate the effects of what would otherwise have been the approach as adopted in Svensson. If my learned friend wants to dispense with that mitigation, we're not going to complain. Unless I can assist the court further, those are my submissions.
Any justice raised?
No questions from me, thank you.
Lord Justice Arnold?
No from me, thank you.
Thank you very much, Mr. Cullen. Mr. Howe?
Yes, my lords, my lady, I'm going to reply broadly in the order of appearance in my learned friend's submissions. And obviously I will confine myself to points of reply and not repeat submissions I have made previously. Just by way of a preliminary point, can I deal with the question raised by the court yesterday, which is whether or not the court should consider a hypothetical Category 3 station, which is, say, a foreign station, which was operating under a voluntary licence rather than a statutory scheme or equitable remuneration scheme. My lords, we agree it would be sensible for the court to consider the position of such a station. It would assist parties to know the position in relation to that type of station. We understand, of course, that any consideration of that would have to be hypothetical and be based on assumed facts or possibly speculative facts. But nonetheless, since it's a matter that the court has heard arguments about, it would be helpful to know what the court's view on that type of station might be. Turning to the points in reply, the first broad area of submissions that my learned friend made were devoted to the proposition that Tunein operates at the expense of stations and rights holders, and is no better than or different to, in substance, an illegal operator such as the Pirate Bay or other similar operations like Newsbin that have been considered in a number of the cases that we have seen. We submit that these propositions are false and very far from the true position, very far indeed. Starting first of all with Tunein generally, there is, we submit on the evidence, no comparison at all between the nature of Tunein's business and the type of operators such as Pirate Bay and the like, or Mr. Woolham's film spieler device that the court have considered on other occasions. The very purpose of those sorts of services is to enable the accessing and sharing of knowingly infringing materials. That's the main purpose for their use, although non-infringing materials may also be shared through these mechanisms. That is purely incidental. Tunein, by contrast, is a substantial and highly reputable business which has operated for many years, providing its service in many different countries. In its main centre of the operation in the US, it operates, as you've seen, a notice and takedown system under arrangements with the relevant licensing bodies. In these proceedings, it was asserted that the Tunein, initially, in the initial correspondence, it was asserted simply that Tunein was not permitted to provide its users with links to non-UK stations. That was the starting point for the in the correspondence report action. It was only when the claim was in fact issued that the claim was broadened, suggesting that Tunein couldn't provide its users with links to UK stations either. But the point is this: from the outset of this dispute, what was being raised was the difficult question of whether providing a hyperlink to a foreign station was or was not a communication to the public by Tunein, which, as one can see, is a difficult issue of law, particularly in light of the developing Court of Justice jurisprudence, which has occupied several teams of lawyers and now 5 judges, I think, in total for a period of time. So to portray Tunein as being akin to a pirate operation knowingly engaging in infringing activities is, in our submission, simply a completely unfair presentation of the reality of Tunein's operation and its business, and of the nature of the dispute between the parties. And one of the unfortunate aspects of this dispute is that the respondents have persistently sought to align 2 quite different issues. One is the issue, which is a difficult question of law, as I've said, mixed in with questions of fact, as to whether or not providing a hyperlink to a station based overseas is or is not a communication to the public by Tunein. Another separate issue is how quickly does Tunein act when it's told about a station that is not operating lawfully, which is quite a different matter. And the evidence below traversed both issues, but it's not helpful in our submission for the respondents to seek to allied the two and seek to portray that because Tunein has taken the position that it doesn't require a license to link to foreign stations, it is therefore deliberately infringing copyright or doing anything of that nature. That is not so. And of course, the judge had before him extensive evidence from Tunein as to its copyright policies and other methods by which it dealt with its takedown notices in the States and so on and so forth. Next, as regards the issue of advertising. My learned friend again made the submission that I referred to briefly in my submissions and is contained in the respondent's skeleton, the non sequitur proposition that because Tunein is advertising and obtaining revenue from advertising, it is doing so at the expense of the radio stations and the rights holders. Now, obviously, the respondents are very substantial global organisations with unlimited, effectively, resources at their disposal for investigating and bringing forward evidence if they thought it was relevant. And if they thought it had been important to present to the court below evidence that the effect of Tunein service was to depress radio stations' revenue and thereby rights holders' revenue, then that evidence could easily be collated and presented. Obtaining evidence from radio stations who were complaining, or by providing calculations based on revenue before and after joining the Tunein service, or any other method one can think of. No such evidence was presented, and what we have instead is an assertion, unsupported by any evidence, that the effect of Tunein's activity is deleterious to the rights holders and to the stations. There is no basis for drawing any such conclusion, because it fallaciously assumes that Tunein's activities in providing this search platform of radio stations to listeners depresses the size of the cake. And without any evidence, there is no reason to suppose that that is so.
Well, it depends how you look at it, doesn't it? I mean, I appreciate the point you're making, but if one supposes that the claimants are correct, and that therefore the consequence is that your clients need to take a license from PPL, then the starting point is that what has been lost is the distributions from PPL.
Well, my lord, that's a slightly different question, which is what Tunein is doing an infringement of copyright and therefore something that should be licensed? Clearly, if it's something that should be licensed, then there's a license fee that's likely to be payable if such a license exists. But I'm addressing the rather separate question, which is, as it were, a jury point that my learned friend put forward, that one can infer that because Tunein advertises beside the screens when they're playing, doesn't take users to the station website, and sometimes, in some cases, plays a pre-roll advert before the screen connects, that has an effect of taking away money from the station holders. And the problem with that is that, as I say, it's a non sequitur. The position is that that would only occur if the effect of Tunein's activities was to have either no or a negative effect on the listenership of the stations, as to which there is no evidence, first of all. Secondly, it's reasonable to suppose that the radio stations, being rational actors, are on the Tunein platform if they have joined voluntarily, as many of them have, because they perceive it to be beneficial to them. And there are, of course, a number of reasons why it would be beneficial to a station to be on the Tunein platform, completely divorced from the question of whether people from abroad or not from outside your territory can listen to the station. And that is because, although obviously in this case, inevitably as one gets in trials, the focus has been on the question of foreign access to foreign stations by UK users, and a little bit on vice versa. Of course, that's not mainly what the Tunein service is about. The Tunein service is primarily about providing people with a convenient way to listen to their favourite radio stations. And as the usage figures show, the favourite radio stations of the great majority of users are their local stations or their in-country stations. What Tunein does, which is of benefit both to the users and to the radio stations, is it effectively provides a portable radio, which is convenient for users to use. One can use it in the home, connected to a speaker or not. You can take it out if you go for a walk, and so on and so forth. It provides an easy way for users to find and listen to their favourite stations. And that is why, of course, Tunein has relationships with a number of the major broadcasters in the UK. They have those relationships not because the major broadcasters are seeking to attract large numbers of users from overseas, but because they consider it beneficial to them to be able to use the Tunein platform or provide the Tunein platform as a way for their users to access their streams because of the benefits it offers. And amongst the other benefits, of course, are the fact that Tunein also is connected to some devices, such as the one we've discussed, the Amazon Alexa device. Again, it's simply a convenient way for users, listeners, to access stations they want to listen to. And as I say, one of the problems in a case like this is one tends to focus on one particular aspect of the service, but that's not the primary focus of the service at all, from Tunein's point of view, or indeed from the radio station's point of view. Just bringing that point up, for example, there's a bit of evidence, I showed you some of the tables about listenership of the sample stations, I think on Monday, but also Mr. Straley explained a bit more about the listening figures in the supplementary bundle at page 173. Paragraph, sorry. At paragraph 38, for example, he refers to the charts, but he also explains, I've asked our data team to look at the types of stations listeners in the UK choose to access via the Tunein directory, and enclose an exhibit of the list of the top 10 stations in 2018 by users in the UK. This shows that the BBC stations are the most popular stations people use our service in the UK. There's also a mix in listening between music, BBC Music, Classic FM, Heart, Magic, and news, sports, talk radio, BBC Radio 4, BBC Radio 5, etc. at the top of the listenership. And then he goes on to talk about the size of the directory and provides some tables, sample stations in relation to those on pages 174 through to 175. And on page 176, he refers to another exhibit with a table for further analysis of listening hours data, setting out the ranking of each of the sample stations by average number of daily listeners between 2018 and 2016, which are the charts I referred you to before. This demonstrates the sample stations from outside the UK generally have a much lower ranking in terms of UK listenership than stations from the UK. By way of example, BBC Radio 2 is the second most listened to station in the UK between 2016 and 2018, whereas the highest ranking non-UK sample station is outside the top 300 ranking. And connected with that, my own friend made reference to another list. I'm afraid we had a lot of lists at various points below. Another list of, I think it was 6,000 most listened to stations by listener hours that had been presented as part of the evidence, and said that of the 6,000 stations, 80% were foreign. However, of course, that's not a relevant or useful figure to have, because there are a very large number of stations in this world, and only a small proportion of them are in the UK. Therefore, it's not surprising if you simply order all of the stations that people access from the UK using Tunein, then you will end up with a very long list of stations with a small number of stations with high listenership at the top of the list, and then a very long tail of stations that are hardly listened to at all behind that. And counting up the stations doesn't tell you anything very useful about the pattern of listenership of what people listen to in the UK. And this is a point that was explored in cross-examination with the respondent's witness, Mr. Grant, who I think produced the list, or in any event referred to it. And this that extract is in the additional supplementary bundle, tab 2, at page 17. Starts at page 16, in fact. At the bottom of page 16, page 316 of the transcript, line 22, I was asking Mr. Grant about this list and referred to his evidence in this of the stations included in an Excel spreadsheet created by Tunein, then reading to it. 80% are operating from outside the UK, and then we refer to the list. And turning to the questions, in the middle of page 317, you look at the list, we can see the list is organised in descending order of listening hours. Looking at the first page, for example, it's fair to say the great majority of the first page and stations are UK stations, to which Mr. Grant agreed. Quite a task to a full analysis, but also the listening hours rapidly fall off with TalkSport at the top, 606,000. By the time you get to the bottom of the page, which is capital extra, we're down to only 26,000. Then over the page, the hours decline dramatically. So looking at the total number of 6,000 stations, whatever it is, saying what percentage of them are non-UK stations is probably not the best way to analyse. You want to know how much of tuning service is devoted to UK listeners, is it? I think based on the information we had at the time, it was a reasonable way to analyse it, but there are probably better ways that we had the data, a better way to analyse the listening hours and work out percentage devoted to UK. And then that would be one way. Yes. And the question continues over the page to the top of page 319, similar effect. It's a short point, but it's a list that's been referred to before. It wasn't a good point below, and it's still not a good point now in our submission.
That might be a convenient moment, might it, Mr. Howe?
Yes, my Lord.
How long do you think you're going to be with your reply submissions?
My Lord, I would anticipate about an hour, maybe slightly under.
Very good. We'll resume at 2 p.m. Thank you.